Hello, everyone, and welcome to this lecture, Not So Easily Tailored, an Overview of Fashion Law. My name is Morgan. Thank you, Luke, for introducing me. I am a New York attorney and entrepreneur. I worked in various areas of the fashion industry, both legal and business sectors. In this lecture, you will see just how vast of an area fashion can be and how it is unique in that one may encounter many different segments, hence the name Not So Easily Tailored. Navigating these can be a challenge, but being aware of the issues that one may face allows you to be one step ahead of the industry. Today, we're going to touch upon different areas of the law that fall within the fashion umbrella, and these include employment, labor law, corporate social responsibility, the rise of e-commerce, IP, social media and advertising, and government regulation. At the conclusion of the presentation, as both Luke and Alex mentioned, there will be time for a Q&A, so please make sure to keep a mental note or mention them in the chat so you don't forget them at the end. So when one normally hears the term fashion or fashion law, they are likely to instantly think about clothing, perhaps a large-scale production of a runway show or shopping at your local mall. In fact, fashion law is a specialty practice which covers a wide range of legal practice areas that may arise through the fashion life cycle. This begins at the beginning, from coming up with a business idea to designing the products, through the process of getting those items manufactured, to being displayed in ways in which the consumer can shop them, and finally being able to be purchased by those consumers. Throughout this life cycle, there are various and continuing business and legal issues that arise and must be addressed. In 2020 alone, the fashion industry had a global market value of 1.5 trillion. That number is expected to grow even more by 2.25 trillion in 2025. The largest focus is usually on apparel, footwear, bags, and accessories. As seen by the following chart, the revenue is only expected to increase as these years continue. Although the design process of fashion is very important within the industry, other areas that one may encounter during the practice of fashion law include sourcing goods, the manufacturing process, media and PR. The beauty industry is also very involved, as well as modeling, the distribution of the goods, and the retail sector. So while the fashion world is global, this lecture will address a general summary and overview of topics that involve US regulation and legal points of view to consider in businesses of varying sizes. Of course, there are many more topics that could be discussed since it is an industry that covers such a wide scope. But it's also important to keep in mind that in the US, laws may differ depending on the jurisdiction. The laws that may apply to an area, such as employment law, may differ depending on your location. So for example, the US sets a minimum federal wage standard, but individual states are allowed to set their own minimum wages as long as it meets the federal rate, which employers must pay to their employees. To be even more confusing, the cities within those states can set their own wages. So for example, New York City has a different minimum wage rate rather than New York State. While I'm using the federal minimum wage as a comparison example, this concept can also apply to any of the other topics that we will discuss. And as with all of these subjects, a whole course or numerous lectures can be given on one single topic. So today I'm just going to highlight and lightly touch upon different topics within the fashion law and business sector that one may encounter. The first area we'll dive into is employment law or labor law. In the US alone, there are an estimated 1.8 million individuals who are employed within the fashion industry. These positions can range from the manufacturing process and all the way to marketing and sales departments. There are various hiring classifications that employees may fall under. What they are classified as will provide the employee different protections, as well as different requirements for the employer, such as tax and legal considerations. The first one to consider is at-will employment. At-will generally means that an employer can terminate any of their employees for any of these reasons, except for an illegal one. Similarly, that employee is free to leave that job for any reason at any time without legal consequences. It also means that an employer can change the terms of their relationship with no notice. So this can include a change of pay or benefits. There are, however, limitations in place to protect employees by both federal and state law. Title VII of the Civil Rights Act prohibits an employee or job applicant from discrimination based on race, color, national origin, sex, or religion. This includes all aspects such as the hiring process, termination, promotion, compensation, training, etc. It also prohibits retaliation. An example of a local government that takes further action would be New York's law. Some of the further classes that are protected in the state and city include age, immigration or citizenship status, gender identity, and sexual orientation. The next classification is unionized employees. A unionized employee is represented by a labor union, which is an organization that acts as representatives between the members of the union and the business which employs them. The main purpose of the labor union is to provide the unionized employees the power to negotiate with their employer on their conditions and benefits through collective bargaining agreements. Protections of these are generally found under the National Labor Relations Act. A majority of union members are usually found in the public sector as opposed to private sectors. And a collective bargaining agreement generally just covers various hours or various topics such as wages, hours, benefits, and physical working conditions. Like I said, that can be negotiated. The last classification we will touch upon are independent contractors. An independent contractor is not directly employed by a company. Instead, they're considered to be independent. They may be hired for a specific project or just a temporary short assignment. Generally, someone who is hiring an independent contractor only has the right to control or direct the result of the work and not how or what will be done based on it. So many employment agreements and contracts include popular clauses in order to protect both of the parties involved. This may include protecting things like confidential information, key talent, or overall brand image. The first one, non-competes, is when an employee agrees not to work with or for a similar profession for a specified period of time after they leave that employer. This could prevent employees from divulging sensitive or valuable business information if they were to begin working for a competitor or similar business in the industry. Non-competes may be upheld if they are seen as reasonable. So this includes both the durational scope as well as geographical. So for example, a court may not find that a non-compete is reasonable if it were to encompass a 5+ year restriction and encompass the entire US. That just would not be fair to an employee to be able to find a new position. There must be a balance found between employers wanting to protect their secrets in their business while balancing that with employees not being restricted. Another interesting clause that can come up are morals clauses. This is a provision that provides the employer the option to terminate the employment relationship should the employee engage in misconduct that may negatively impact the brand's reputation. For example, an endorsement contract for a professional athlete may include this provision. If the individual were to do anything criminal or inappropriately behave, and that affects adversely or poorly on the brand, the employee may terminate the relationship. And the last one we'll discuss today are confidentiality agreements. This is a legal agreement that restricts a party to not disclose any confidential or proprietary information of a business. In the course of everyday working environments, employees are exposed to details and information that may be valuable to their competitors. This agreement may impose fines or legal repercussions should it be violated. Within the agreement, employers will want to detail what is the scope of confidential information. For example, does it include ideas, formulas, business information such as suppliers, your budgets? Who are the parties involved? Is it just the employer-employee, or does it also include affiliate parties that the employee may come into contact with? You'll also want to include the duration and termination periods, remedies such as monetary damages, injunctive relief, or other equitable relief, and of course, the governing law. The next area found within fashion is corporate social responsibility. In today's business culture, there is a high level of expectation that corporations must do more than just enhance their bottom lines. In addition to enhancing profits, there is a growing movement that encourages companies to be profitable, ethical, and socially focused. So corporate social responsibility, or CSR, generally means that a business has a responsibility for not only their numbers to do well, but also for the consequences of their actions that result from social and environmental impacts. It's a form of self-regulation of a business with the goal of being socially accountable. Not only are businesses interested in this goal, but so are consumers. Studies have found that nearly 90% of consumers would purchase a product because a company supports an issue that they care about. So some examples in the US that are well known for this are Tom's Shoes. They donate 1/3 of their net profits to various charities. Patagonia, which also donates 1% of their sales, and that goes towards the preservation and restoration of the natural environment. And also Eileen Fisher, which also includes conscious practices within their supply chain. Transparency plays a large role in CSR. Without a clear insight into what the business is hoping to accomplish as their goals, stakeholders would have a very difficult time assessing the business. This can include publishing and making public their reports, opening up their supply chain information, acknowledging labor standards, and many more. Many businesses have taken their CSR goals to a new level. There are various avenues that this can be done, and two popular methods are in the way in which the businesses are incorporated, or by seeking certification to establish that their responsibilities of setting their goals. A benefit corporation is a type of corporation, and it has a legally protected requirement that a company must abide by in their mission statement and actions. To date in the US, there are 37 states that have passed legislation regarding benefit corporations, and 4 are currently working on it. A benefit corporation is required to consider the impacts of any action, not only on its shareholders, but also the employees, customers, community, environment, and the ability of the corporation to accomplish its public benefit purpose. It's actually written into their articles. A B Corp is a certification label that is awarded to a business that becomes certified by the nonprofit organization B Lab. The business must complete and pass B Lab's B Impact Assessment, which analyzes the operations of the business and provides a score depending on how their operations are conducted. So this can include the quality of the products or services, the working conditions provided to employees, and any effect the business has on the environment and surrounding communities. Supply chain management is the organization and management of the flow of goods and the steps that transforms those goods into raw materials into the final product. This encompasses many areas, such as recycling and waste production, sustainability, labor standards, ethics, and the list goes on. It's really important for a brand to know all levels of their supply chain, especially since many aspects occur overseas and in different markets with various laws and standards. Not only could these be violated, but it can affect an overall brand's image. So for example, as a broad comparison, in many countries, it's customary and traditional to use and wear fur in garments, whether that's functional, decorative, or both. In comparison, beginning in 2023, in the state of California, it will become illegal to sell, donate, or manufacture new fur products within the state. So if you're unaware of the supply chain of where your items are coming from and you sold a new garment like that into California at the time, you could be held responsible. Next, we'll move on to the rise of e-commerce. Traditional retail included brick and mortar stores where consumers would go to physically shop in a customary retail environment. Over time, this evolved to new methods of reaching customers, such as shopping catalogs that would be mailed to your house, where you'd call up your order and place it over the phone, and eventually to the internet that we know today. This has and continues to involve numerous legal and business implications, such as negotiating for the appropriate rent and lease dates, insurance aspects. For example, would the landlord or tenant be responsible for something like water damage in the retail location? Purchasing and buying is a very big sector because with traditional retail locations, the purchasing of goods to sell would be based on that region that the store is located in. So now, because businesses are able to reach consumers all over the world, does that mean that business is going to offer a wider inventory? Loss prevention is also a big problem for brick and mortar retail locations. So while online has helped to produce and reduce the traditional theft methods, shipping and fraudulent shopping have also become an issue and grown as a result of that. And finally, you want to make sure you're executing cohesive strategies. So if you have multiple store locations and online platforms, this requires an overall brand image to remain consistent. Consumers want to feel familiar with the overall look and feel of a brand, and they want to see that no matter the format that they shop in. So does the website match the in-store experiences? What about your various social media platforms? Because there are various channels to sell to consumers today, this has provided a shift in shopping habits that affect the overall retail environment and strategy. With traditional retail locations, local and state tax rates would apply in the US. So for example, if a store is located in New York City, the consumer will pay the city and state tax on the items. If you only have a physical presence of a store, the state laws in which you are located with that store will apply regarding the sales and use taxes or any other local taxes. However, with the expansion of online stores, businesses have to understand the tax implications that may arise when shipping to consumers outside of their physical location. So even if a store is online only, depending on the state, the business will owe varying tax payments based on where they're shipping the item or selling to the consumer. The majority of states require businesses without a physical presence in their state to pay sales tax once they reach a threshold of sales into that state. So for example, $100,000. Some other states, on the other hand, want to collect that tax no matter the amount of sales made into it. The past couple of years alone have grown and seen a tremendous increase in e-commerce sales. The rise and expansion of e-commerce provides brands a new outlet to reach customers and gain valuable data about them. Knowing key information about your customers, such as their location, shopping habits, even their size, can be very beneficial to producing that great experience. However, there also comes a variety of new issues that arise surrounding data use and privacy. Privacy laws vary widely based on location, including globally and regionally. Like many other areas within fashion law, certain states have much more strict protections for consumers in place than others may do. For example, California has enacted the California Consumer Privacy Act, which requires further protections, such as the ability for consumers to opt out of the cookie collection on their websites. An important part of a business website includes a privacy policy. These are legal agreements that are found on a website, and they explain what kind of personal information is being gathered, how the information will be used by the business, and how it will be kept safe. These requirements vary based on location and the age. The types of information that could be collected range from just your name, your date of birth, email address, your billing and shipping information, including credit cards, your phone number, payment details. And other things that a policy also may cover include how your data is stored, your affiliated websites that you also may share the information with, and the use of cookies. Because consumers' perspective of privacy rights is ever changing and evolving, as well are the laws, many large brands hire dedicated staff, such as the chief privacy officers, data protection officers, or skilled in-house or outside counsel. Their role is to focus on regulatory compliance, protect consumer information, as well as the brand's reputational goodwill. There are also special protections provided for children online. The Children's Online Privacy Protection Rule imposes certain requirements of websites that are directed to children under the age of 13 years old, or those with actual knowledge that they are collecting using the personal information from those under the age of 13. The Act specifies various extra protections, like requiring parental consent and restricting certain types of marketing. Because this is such a complicated and wide area of law, it's really best to refer to experts in the area. You want to balance the ability and benefit of being able to learn about your customers while also making sure your brand reputation is protected, as well as the laws are abided by. Intellectual property is one of the main assets that a brand can have. Overall, Europe does provide greater protection to fashion designs, while in the US, certain elements of a design and brand may be protected through various methods. The first form of protection we'll talk about today is copyright. A copyright is the exclusive legal right given to an originator or an assignee to print, publish, perform, film, or record literary, artistic, or musical material, and they can also authorize others to do the same. They must be original and fixed in a tangible medium of expression, and they also cannot be useful or functional. So examples in the fashion realm include designs, certain kind of jewelry, fabric prints, and graphics. As a general rule in the US, works that are created after January 1st, 1978 have a protection for the life of the creator plus an additional 70 years after that. A limitation does exist, and it is referred to the doctrine of fair use. This means that a work may be used for purposes such as commentary, parody, academia, research, etc. And courts generally apply a multiple factor balancing test to determine whether it is fair use if a claim should arise. So for example, a fabric print can be protected, but not the item itself, like a shirt or a dress. One of the landmark cases in the US is Star Athletica versus Varsity Brands. The US Supreme Court case surrounded the copyrightability of designs of cheerleading uniforms and the concept of separability. This is the prerequisite for a garment or other useful article to be protected. US copyright law does not want to create a monopoly over useful articles, which includes garments. So dresses, shoes, bags, they are considered useful items and will not qualify for copyright protection as a whole. However, the design features that can be separated from that dress or shirt may qualify for protection. Specifically, in this case, the Supreme Court said that cheerleading designs were copyrightable material. It didn't matter whether the separable aspect could physically break off from the usefulness. The next form of IP, widely known, is a trademark. A trademark can be any word, phrase, symbol, design, or a combination of these things, and that identifies a good or service. It helps to identify the source of the good, provides legal protection, and helps guard against counterfeiting and fraud. Oftentimes, the trademark is the brand name or logo. In the US, there is a first-to-use system, meaning that a registrant must show the USPTO that they are actually using their trademark in order to be granted registration. If the mark continues to be used and does not become generic, the right can potentially last indefinitely, subject to registration renewals. Trademark protection has been found to extend to non-traditional marks as well, such as color, smell, sound, and product configuration. For example, Christian Louboutin's famous red soles are protected in the US. In a famous case, fashion house Yves Saint Laurent released a pair of heels that featured a monochrome footwear collection in a range of colors, including red, as shown here in the right image. Louboutin filed a lawsuit against YSL, claiming infringement of their red sole trademark. In response, YSL challenged the color trademark, claiming it lacked distinctiveness and was ornamental. The court, however, upheld Louboutin's red sole trademark. However, they did limit it to uses in which the red outsole contrasts with the sole of the remainder of the shoe. So while the trademark was held to be valid, here YSL was able to continue using in these specific shoes because the shoes were all the same color in the body and sole. The trademark does not extend that far for Louboutin. Trade dress refers to a part of a product packaging or product configuration. It is a subgroup of trademark law. The functionality cannot be protected if the appearance itself is considered useful. So for example, this is found many times in pharmaceuticals where the color or shape of a pill is functional to the user. Some popular examples include the product packaging of Coca-Cola bottles, Thermès Birkin, and Tiffany blue boxes and bags. These have acquired secondary meaning to consumers, and they bring the brand to the front of the consumer's mind when they see the items. The configuration itself is distinctive, non-functional, and has secondary meaning. In large companies, trademark attorneys are typically responsible for various aspects, such as evaluating and clearing proposed trademarks that the brand hopes to use, filing the applications to register these new trademarks, initiating legal action to enforce and protect their trademarks, and anti-counterfeiting and brand protection work. The last main form we will talk about today is a patent. This is a grant of exclusive rights that an inventor or where the process of product provides a new way of doing something and offers a new technical solution to a problem. They are granted for new and unique inventions. There are different categories that include a design patent. These are based on a product's decorative and non-functional features, and they are new, original, and of ornamental design. There is generally a 15-year protection window before expiration. Another form is a utility patent. These are inventions of new and useful processes, article of manufacture, or any improvement thereof. There's a general 20-year protection. Once the patent is granted, the holder has the exclusive right to exclude others from making, using, or selling their invention through the US, and they can also prevent it being imported. They also may license the right. So examples in fashion may include handbag designs with unique and ornamental elements such as metal studs and the appearance of the iPhone. So while nothing functional or useful can be subject to copyright or trademark law, design patents may be a better avenue of protection. However, they are more expensive and time-consuming. As fashion fashion is an ever-changing field from season to season. Many brands may not see the value in pursuing this type of protection, while others may benefit from it. Because intellectual property is arguably one of the most valuable tools for a brand, it allows them to protect their name, build goodwill, and set them apart within the marketplace. Because of that, it's extremely important for brands to protect their assets. This can be done in a variety of ways. You want to make sure that there are procedures in place to protect confidential information. This may include aspects of the design process, new concepts, future plans, or any relevant material. Confidentiality agreements, or NDAs, are popular for this reason. As previously discussed, there are various ways to protect your intellectual property based on the asset. Despite having certain protections without having to register, some avenues may require filing and registration prior to any publication, making it public, or the ability to bring any infringement claims. Litigation can also be costly, not only in the monetary aspect, but for timing and planning purposes. Cease and desist letters are used when it is found by a brand that someone is violating their protected IP. They are much less time and money consuming, but allow the owner to assert their rights. In the letter, you'll want to include who you are as a brand and that you are the owner of the protected asset. You want to state that it has come to your attention that the trademark or valuable asset is being used in connection with the offering of these specific goods or services. You'll want to include examples of how they are using your mark. If it is a trademark that is being infringed upon, the use could be likely to dilute the distinctive quality of the owner's trademark. And that leads to the possibility of liability under the Lanham Act or possible separate claims under state law. It would be wise to include those points also. Demands in your letter can include to cease and desist all further use of the mark, to destroy materials likely to cause confusion, to cancel specific domain names if they have registered websites under the protected asset, and to provide written confirmation receipt of the letter that you have sent. Licensing is an agreement where a licensee obtains usage of the rights to a legally protected property from a licensor for use of services or products. This license provides the brand owner or the licensor control and discretion over who may legally use their mark in an area that they may not have an expertise in, or if they want to enter into an untapped market. A popular category among fashion brands that pursue legal agreements in the licensing sector are sunglasses. Luxottica is a leader in the eyewear licensing space and includes well-known brands such as Chanel, Burberry, Prada, Ralph Lauren, and many more. One of the main considerations to keep in mind with licensing is the reputation, skills, and abilities provided by the licensee, since they are likely to be more informed in the area that you're choosing to enter into a licensing partnership with. The brand will likely want to defer to them on certain elements of making the product while also maintaining certain control. So why would a brand choose to enter a licensing agreement? As with all business endeavors, there are pros and cons. Some benefits to a licensor include financial gains, increased brand awareness, creating additional product and distribution channels, and the ability to protect and strengthen their trademark on a larger scale. However, the potential risks that a licensor could incur are loss of quality control, product oversaturation, and the risk of harm to their brand image. Some important licensing elements that you'll want to include in an agreement are the grant and an example of the license. What exactly is the licensed property? You want to include the mark and the specific forms. A brand could have many different labels and types, and you want to be able to specify exactly who and what is allowed to use them. The term and termination of the agreement. The scope, is it an exclusive agreement? Does it have a limited geographical region or product range? You also want to include the royalty fee, of course. This is the basic form of payment in a licensing agreement. It's usually a percentage of the net sales price of each unit of licensed merchandise sold. You can also include a guarantee into the agreement, and this is a minimum royalty payment. Actual royalty payments accrue against the guarantee. So whatever remains of the guarantee amount after the total royalties are equated, that will still be payable to the licensor. The manufacture of articles and quality control. This could include specific items such as a dedicated staff or suppliers to be working on the products. It can also require design and approval by the licensor to retain control. Distribution channels. A list of approved retailers is strategic, so the licensor has an idea of where their products displaying their name will be sold. Also, in case of termination, you'll want to have certain points to find out ahead of time. These can include financial obligations, such as if there's a bankruptcy or change of ownership in a brand, and what also may happen to any leftover inventory. And then, of course, you'll want to include other standard contractual elements. The dealing of counterfeit goods and products trades upon the strong reputation built by brands. While some may view the idea of using a counterfeit product as harmless, it is in fact not a victimless crime. It is a common misconception by consumers that buying counterfeit merchandise is harmless and they're only obtaining a good deal. Unfortunately, this is far from true. In addition to the reputational harm that can be done to a brand, it has been found that counterfeit products aid in the loss of jobs as well as tax revenue. Furthermore, the global sale of counterfeit merchandise has been tied to the illegal sale of drugs, human trafficking, terrorism, and child labor. Counterfeits are sold in retail locations as well as online via websites and social media. In fact, there are dedicated showrooms to counterfeit items in large cities such as New York, LA, and Beijing, where shoppers can go in and act as if they're shopping in a normal brick and mortar retail environment. As you can see from the chart, in 2020 alone, there were billions of sales lost in the retail sector. It is imperative for IP owners to protect their marks or face the possibility of losing their protection. So owners should mark their IP with their proper designations. Brands should also be constantly monitoring for various forms of infringement, such as counterfeit products. Some enforcement strategies include sending cease and desist letters, as we previously mentioned, monitoring and reporting to various online outlets where infringement may take place, such as social media sites and third-party selling sites like eBay or Amazon, consumer education, pursuing legal action against counterfeiters and infringers, and even working with law enforcement such as US Customs or local agencies. Our next topic is the growing popularity of social media and advertising. Social media has become a very powerful tool within the past decade. It allows brands to build awareness, create new methods of marketing, reach new consumers, and build additional revenue streams. With various platforms constantly being developed and emerging, it's important for brands to learn how to harness that power of social media, but also understand the protections that must be put into place. Intellectual property rights also play a large role in social media, specifically when it comes to user-generated content. User-generated content is any form of content such as images, videos, text, or audio that is created or posted by a user on social media. The way this could come into play in the area of fashion may be when a user tags a fashion brand in a post on Instagram. When the brand notices that image and wants to repost it on their own profile, certain steps should be taken. This may include getting the explicit permission of the user, as doing so without may infringe upon their copyrightable protections. Additionally, influencer marketing is a growing area that many brands have seen successful results in. This is another area that has increased in regulation. The Federal Trade Commission, or FTC, is an independent government agency that promotes consumer protection. They seek to eliminate and prevent unethical business practices while protecting consumers and promoting fair competition. The FTC releases guidelines to provide assistance to brands, so their advertising will not be misleading to consumers. This enforcement is found under Section 5 of the FTC Act. This provides that unfair or deceptive acts or practices in or affecting commerce are declared unlawful. Specifically, the FTC has determined that a representation, omission, or practice is deceptive if it is likely to mislead consumers and affect consumers' behavior or decisions about a product or service. This is directly related to social media advertising, as the FTC has recently focused on ways in which digital marketing impacts consumer shopping habits. When a brand provides items to an influencer, for example, either with or without additional payment in exchange for promotion on their social media channels, this must be sufficiently disclosed into the post. The FTC has stated that certain disclosures used are not sufficiently clear, as consumers will not understand that this demonstrates a connection with the brand. For example, if an influencer posts an image and they're wearing items that were sent to them for no charge, and only tags the brand in the image, this would not be sufficient disclosure. In this instance, there is not enough disclosure of a material connection. Many times, influencers post and tag brands without receiving the product or monetary compensation in exchange. They're simply sharing their outfits or their preferences with their followers. The FTC has stated that disclosures such as ad, promotion, sponsored, gifted, or hashtags like hashtag ad, hashtag brand name of the partner are acceptable and required forms of disclosure. So while it may be apparent to industry insiders that these individuals are receiving items for free or given other benefits in exchange for posting, an act or practice, according to the FTC, is deceptive if it misleads a significant minority of consumers. This means that even if some consumers are aware of the connection, others may not be. If brands choose to invest time and money into influencer marketing, it is important to develop a complete social media strategy and policy. This would include a proper way to instruct and make known to any partners how to properly disclose, as well as any specific requirements that a brand may have when producing content. To further expand on advertising law, as stated, the FTC Act prohibits unfair or deceptive acts or practices in or affecting commerce. An advertisement would be considered deceptive if it contains representations or omissions that is likely to mislead a consumer acting reasonably under the circumstances. And that representation must be material to a consumer's purchasing decision. This could occur in various ways, such as false claims, like stating a product is all natural, or if it fails to disclose material facts, like we talked about with influencer campaigns, or if there are any unsubstantiated claims, if there's no scientific evidence behind it or studies done. You want to be careful on the wordings and claims made by a brand themselves or by any groups or individuals acting as endorsements for the brand. Music also plays a very large part in the fashion industry, whether it's used for marketing materials such as commercials, social media, or in the use of live fashion shows. Or you can also enhance your in-store shopping experience. These are various concerns to keep in mind by brands. Just like other forms of art, music has various copyright and IP protections afforded to it. This includes live performances, as well as even having a song play over TikTok or Instagram Reel videos. Because of copyright protections and not wanting to pay royalty fees, many brands choose to use original audio. Additionally, there are avenues for brands to explore where licensing can be done so they can use those popular songs in their promotional material for commercial use. The last overview today will be for government regulation. There are various ways in which the government regulates the fashion industry. As previously discussed, they play a hand in regulating advertising, employment, online protections, and IP. Another interesting area in which they govern and have oversight are the requirements related to the labeling on clothing, safety, and global trade. So those tags that you may find itchy on the back of your shirt, or you only look at to see like when you're shopping if it comes in your size, actually provide much more information than you may think. An important part of a label includes the RN number. This is a registered identification number, and it allows a business responsible for the product within the US to be known. A business may choose to list their RN number or actually display their business name. The textile fiber rule dictates what's required on a label. Under federal law, this is the fiber content and the country of origin. The fiber content will be by percentage in descending order by the amount found within the item materials. If the item is something specialized, such as fur, there are also additional requirements, like the name of the animal, the country of origin, and information about the treatment of the item. The Care Labeling Act is also required under law, and this is the washing or care instructions of your garment. This includes the complete instructions about regular care, or providing a warning if the garment cannot be cleaned without harm. This is when you would see a label such as dry clean only. Once again, the FTC plays a part in the enforcement of these rules. Safety is also a very important area that the government plays a role in regulating and monitoring. The Consumer Product Safety Commission has authority over various consumer products within the fashion industry under the Consumer Product Safety Act. The flammability Fabrics Act regulates the manufacturing of highly flammable clothing. And under this act, the CPSC issues standards that must be met for these textiles. Such examples include clothing and children's sleepwear. Children's clothing also has other areas of concern for good reasoning. While certain accessories and parts may be acceptable to have on adult clothing, things such as buttons, drawstrings, or small parts must undergo regulation and testing, as well as follow proper placement rules on the garments. The CPSC also has authority to recall consumer products for various reasons. This includes when a product creates a substantial risk of injury or hazardous situations to consumers. Before a product is put into the market, brands should definitely make sure the proper testing is done, as well as sufficiently determining that all safety standards are met. Global trade also plays a large part in the fashion industry. Much manufacturing takes place overseas today, and that requires the finished product or item to be sent or imported into the US. With that comes additional costs tacked onto items that can really fluctuate based on various factors, such as inflation, politics that are playing out in the current market. A tariff is a duty or additional cost that is imposed on specific imported goods in the US. These vary widely depending on what the product is and where it is being sent from. In the US, tariffs have been part of the industry since 1930. During the first 9 months of 2021, the US apparel industry paid an estimated $15.1 billion in tariffs. This equated to 24.6 or almost 25% of all tariffs collected. These numbers are important because although the importers or businesses are paying the tariffs when they bring them into the country, that cost is usually passed on to the consumer in their retail price. So while tariffs are never likely to actually fully disappear, businesses should keep a close eye and monitor shifting markets and how they may affect their bottom lines. So as we've seen today, the area of fashion law covers a wide range of legal practice areas. It provides a unique and special avenue for attorneys to be involved in various aspects of the fashion business. Whether you have an interest in labor or employment law, IP, social media, or just fashion in general, the ever-changing fashion industry will keep all of you interested on their toes for sure. Thank you to the Center for American Studies for hosting this lecture. I've posted my email and social channels, so if anyone has questions or comments, you can feel free to reach out to me, or if you have questions now, I'm happy to open the floor, and thank you all for joining.
Okay, thank you so much, Morgan. If you have any questions now, I will turn on your microphones, and you can feel free and ask the questions. Okay, I turn on your microphones. We are waiting for your questions.
I actually have one. I'd like to ask about trademarks because I heard that it is possible to trademark a name like Beyonce did for her daughter, Blue Ivy. And I'm wondering, how is that possible and how does she prove that she is using the trademark?
So I'm not specifically familiar with what Blue Ivy has done in like the fashion industry or different areas, but a lot of times celebrities are able to trademark their own name. So for example, let's say Beyonce and Jay-Z have gone ahead and delved into the children's fashion clothing realm or some other aspect or music or something else has been put out with her name. That would be a way that they could prove usage.
Thank you.
Yeah.
Okay, thank you. Anybody? Somebody else? You can really feel free to ask the questions from Morgan.
Of course. And if you think of one later, you can always send an email as well.
Yeah.